Davis here was telling him to leave, it would be the G4S security members, not anyone on the city commission. And in fact, one of the points here is that, and as Mr. Gilbert said it, everyone was asked to leave the city chambers. And it was solely Mr. Davis who remained after chambers had been cleared out. This is not a situation where the commission, they intended to go forward with the meeting and one of the commissioners said, you know, he's out, I don't want him in here while we're doing our public business.
All right, thank you, Mr. Zummel. I'll go back to Mr. Gilbert and then Mr. Taylor will give you the last word. Mr. Gilbert.
Yes. So one distinction I would like to make is that one of the witnesses, Amanda Fritz, Commissioner Fritz, was the person who allegedly was bothered by the light on Mr. Davis's camera. And so I think that she clearly has some information that's different than what everybody else has. Also, I want to remind the court that the issue for the defense is not, you know, who gave the order and did that person have the legal authority to give an order. The issue for the defense is, was that order lawful? And in considering that question, the court and the jury must consider whether it was constitutional. Now, we'll flesh this out more in the trial, but it's our position that Mr. Davis had a constitutional right to remain, a right to and some other stuff that I'm sure Mr. Davis will remind me to tell you in a moment. But I also want to draw the court's attention to the source of those constitutional rights. So this is about, among other things, about free speech, but it's also about the right to compulsory process to obtain witnesses in his favor. And that's under Article 1, Section 11 of the Oregon Constitution. And there's also federal compulsory process rights. He also has a right under Article 1, Section 26 of the Oregon Constitution to assemble and petition his government for redress of grievances. Those rights, like all constitutional rights, are not unlimited. But it is incumbent upon, when challenged, for the state to establish that they were in compliance. So all of this, in the testimony of the commissioners, would be relevant to this matter. And Mr. Davis does have a right to bring witnesses in his favor. And witnesses who were there at the event, who watched it, from different angles, each with a slightly different experience in life, and different perspectives on the proper role of government and the proper role of individuals in the community to redress their government, to petition their government for redress of grievances. That's all information that would be provided to these witnesses. And none of these are the same. There's nothing cumulative about that. And so because Mr. Davis has the right to call those witnesses, we're asking the court to uphold the subpoenas. But if the court is inclined to quash these subpoenas, this completely upends our theory of the case and our trial tactics, everything that we've been working towards since May when these were served. And so, quite frankly, we would need to subpoena additional different witnesses who presumably don't have such important matters that they can't obey a trial subpoena to give testimony in a criminal case.
Well, why didn't you do that, just in case I granted the motion?
Because these are fact witnesses, eyewitnesses to an event And they clearly saw what happened. Nobody has disputed that. They've just asserted that without any real foundation that it would be cumulative and that it would somehow, everything would be on a video or through the other witnesses. And we don't know that, and we're not in a position to know that. That's why the court must uphold this subpoena unless it's clear that that the evidence that they would give has no potential use at trial.
Is that the standard? I thought the standard was that you had to show materiality, favorability, not that the shoe's on the other foot, that it needs to be them showing that there's no potential value.
I'm not sure on that particular point.
Okay. Great, Mr. Taylor, go ahead.
Thank you, Your Honor. The standard is it must be reasonably likely to lead to material and favorable evidence. That any testimony or the emails aren't material because they don't go to the lawful order given by Ms. Guerrero. They're certainly not favorable to the defense. There's been no showing how any of this information by the two members of counsel who are available would be favorable to the defense. And as we have suggested, we're concerned about the disruption that this would cause if in the future, every time somebody disrupts the counsel and is prosecuted for that, their trial tactics involve subpoenaing every member of counsel to show up and testify, because there's obviously logistical issues. And plus, those members of counsel they're not material to the facts in that prosecution, and it's not favorable, and the defense can't take that showing. That's why we ask the court to watch this.
I understand the arguments on both sides, and I understand the defense argument to be with respect to the emails, that they could potentially have information that reveals the bias of the city council and any influence they may have had on the people who gave the lawful order to eject, to give the order, whether or not it's lawful, to eject Mr. Davis. I think that that combined with the information that we have from the city attorney's office, that no such emails exist, that request is unduly speculative. There is no reason to believe that such emails exist. So I will grant the motion to quash with respect to the emails. With respect to the testimony of the city commissioners and the mayor, I will also grant the motion to quash with respect to them. My understanding is that there are two potential bases of relevance for their testimony that the defense has identified. One is that they may have had a different perspective on the events in the city council chambers that led to the ejection, that led to the alleged criminal behavior that occurred afterward. However, it sounds like nobody in this room has a specific basis to believe that such a difference in perspective exists that would be material or substantive or favorable to the defense. So I think that basis for potential relevance is also unduly speculative. The second basis is that these city council members may have had some sort of influence over the people who gave the order to eject Mr. Davis, and that influence may have been biased, and that bias may have been in some way unconstitutional or affect the lawfulness of the order to eject. Again, that's a lot of ifs, and I think that it makes that chain of reasoning, again, far too speculative. We don't have any reason specifically to believe that that is the case. And for that reason, I don't think it's appropriate to call those people as witnesses. I also am taking into account the disruption and inconvenience to the city, and then weighing that against what little benefit there may be in calling those people as a witness, and that is also a factor for my However, even independent of that, I don't believe that the defense has made the requisite showing. So even if it weren't for that inconvenience, I would still reach the state conclusion. So that'll be my order on the motions to quash, and anything else that we need to put on the record before we move on. Thank you, Mr. Taylor.
Thank you.
All right, let's talk about motions in limine and with the state. Mr. Zell, do you have any pretrial motions?
I have no pretrial motions. I do have some thoughts about jury instructions, and I know we'll get to that later, but I do think that this point will be relevant as far as objections and things will go during trial, so I want to bring it up before we start anything. The defense has requested a jury instruction about its defense to trespass if the order to leave was unconstitutional. So I want to make clear that one, in that very same case cited by defense, says that that case actually was ruled in favor of the state, and said the basis of the ejection from a public place is a disruption, then it is lawful. It can't be based on the content of speech. And second is that irrespective of that, this was not a premises open to the public because Chambers was cleared, everyone was asked to leave. There was not public business going on in that moment, and that the constitutionality as far as freedom of speech wouldn't apply if at that moment in time it was not a premises open to the public.
Okay, and I just want to make sure I understand the import of that information.
Right.
That's describing the basis of potential relevance objections that you anticipate you might have to make during a trial. Is that what you're telling me?
Correct, as well as some of the use of force components that I think you can see, you anticipate defense to bring up that I also don't think would be relevant.
Okay. All right. Okay. So thank you for that background. Mr. Gilbert, any motions in the meeting that the defense has?
No objection.
Okay. All right. Let's talk a little bit about jury selection. So we'll call, it is a jury trial, is that right?
Yes.
Okay. So we'll call up, I was thinking about this, thinking we probably need at least one alternate. Does anybody think we need more than that?
No.
Okay, so we'll seat 7 jurors, and the way I do that is we seat all 7. We don't pick an alternate in the beginning, and the reason I do that is because I want to make sure all 7 people pay equal attention to the testimony and the arguments. So I don't want anybody to know that they are the alternate. I also want to tell them in the beginning and ahead of time that there will be an alternate, and that the alternate will be selected at random at the end of the trial. In my experience, that seems to go over a little bit better with the person who is ultimately selected as an alternate. They feel a little bit less like their time was wasted if we do it that way. So that's how I'll do that. So we'll seat the 7, and then in addition to giving you the 3 regular peremptory challenges that you would normally have, I'll give you an additional one. So each side will have 4 additional, we'll have 4 peremptory challenges total, so 1 additional, and you'll be able to address those at any of the presumptive 7 who we have submitted. So, any questions about that? I also give a jury instruction at the beginning and after they're seated about alternate jurors, just explain the process so that there is one and that we haven't picked one yet. So I'll let everyone see that in a moment. The way we'll seat them is presumptive juror number 1 will be seated in the back corner over here. And number 1, 2, 3, 4, 5, 6, 7. So what that means is our presumptive 7 are all going to be in the back row, 1 through 7. And then we can actually probably take out, let's take out the 2 chairs that move on either end of the first row. And we'll seat the next 5 in the box in front of the presumptive 7. So then it'll go 8, 9, 10, 11, 12. And then I'm thinking we're going to call up 30 total because I think that we'll have some hardship. reasons to address. People can't serve all 4 days. So 13 will start on this bench that's behind Mr. Gilbert. And it's going to be in the spot closest to the door. And we'll go 13 through, let's see here, grab my chart. We'll say 13 through 21 in that row. And then 22 through 30 in the next row. We'll see if we can get everybody fit into